Welcome viewers to the Personal Injury Law Show. This is a show that talks about slips and falls, transport accidents, work accidents, medical negligence, anything to do with personal injuries. My name's Tony Carbone, personal injury lawyer of over 25 years experience. With me tonight I've got Alice O'Connor, insurance lawyer.
Good evening, Tony. Good evening, Professor.
And a special guest tonight, Professor Spencer Zifchat.
Hi Tony, hi Alice.
And the professor is a graduate of the University of Melbourne. He has a PhD at the University of London. He's a professor of law at Australian Catholic University and president of Liberty Victoria. Now, tonight's topic, viewers, is going to be about surveillance and the interaction of surveillance with civil litigation and the Charter of Human Rights.
But before we get to that, Tony, what's in the news?
Well, Alice, what's in the news is something that's relevant to this topic. We've got a Mrs. Rosa DM, who was working for Toll Holdings, or the Toll Group. She sustained a back injury, Professor. She goes off to a supermarket to do some shopping. They get her on video and they sack her.
That's right, Tony. And I understand that Ms. DM was actually off work on sort of weekly payments from
Workers'
her injury.
compensation.
On compensation, that's right. And she was followed by her employer, who is a self-insurer, and we can explain to the viewers what that means and why that's different from your normal situation. But she was followed to the supermarket, and I understand, Tony, she spent 13 minutes at the supermarket, and then she was sacked on that basis because she was supposed to have an injury.
And, Professor, what's interesting about this case is that what Toll did is what WorkSafe do with just about every compensation claim. They followed him to see how they conducted themselves in view of the injuries they've got. Do you think that that was a good decision by Fair Work Australia to re-employ her?
Well,
reinstate her employment?
It seems to me that a private company can engage in surveillance of an employee where they think that the employee is making a false claim of some sort or another. But if that's going to happen, it's crucial that the employer makes clear to the employee at the commencement of their employment that surveillance of this kind might be engaged in. If they don't, employees can be taken unaware, and that gives the employer an unfair advantage in potentially subsequent litigation.
Viewers, just on that note, we're going to get onto the topic. Professor, in short, what is the state of the law in relation to surveillance?
Well, in the private sector, the interesting thing about this entire topic is that the law is way behind, so that the regulation of surveillance and laws protecting privacy in the private sector workplace is almost non-existent. You've got what's called the Surveillance Devices Act, but the Surveillance Devices Act was passed in 1999. In 1999 we didn't even have an iPod, so it's way behind and needs amendment. You've got the Telephone Interception Act, the Commonwealth legislation, but that doesn't cover surveillance of internet, email and those sorts of electronic communications in which we now all engage. There's no regulation in the private sector of private companies seeking to test their employees, for example, genetic testing, DNA testing, drug testing and so on. That's completely unregulated. And the Workplace Relations Act doesn't say anything about this at all because surveillance privacy is not an allowable award matter, and so the whole privacy issue again falls outside that Commonwealth legislation. So effectively we've got no real control of privacy in the private sector workplace.
Well, just on that issue there, Alice, the big topic of discussion for us tonight is how does surveillance impact on injured workers?
Yes.
What do these investigators have to do to comply with the regulations or the code set out by WorkSafe?
Look, there's a lot of regulation of this in theory, Tony, but in practice I think that perhaps it doesn't always go on. For example, if you look at some of the regulations about privacy when you're conducting surveillance of someone, particularly when they don't know about it, employers are required to look at what's called a privacy impact assessment. Now, I have yet to see one of those in a case that I've run, especially in relation to our clients, because if there's one thing we can never access as a lawyer running a workers' compensation claim, it is any information about whether they've been followed and whether it's going to be used in the case as well. So it seems to be shrouded a little bit in secrecy from that point of view.
Professor, a lot of clients don't realise, or injured people don't realise, that if an investigator parks their car outside their house, they've still got to bring up the local police to let them know that that's what they're doing. And if they've got some doubt about that, they should ring up the police to find out whether they have contacted the police. What else can they do?
Well, at the moment, there's very little that individuals can do to combat the increasing surveillance state of which we're all becoming a part. And that goes back to the point I've just been making. Unless there is appropriate regulation of privacy in the workplace, unless there are clear rules, and unless we get a workplace privacy regulator of some kind in Victoria or even across Australia with respect to private sector workplaces.
Professor, this is not
essentially,
the workplace, this is outside the workplace, this is outside a person's home.
Yes, indeed. As I said before, an employer can actually engage in surveillance of a person outside the workplace and indeed outside a person's home. But that's because we don't have any effective workplace privacy regulation. And when I talk about workplace privacy regulation, it means that an employer will be able to engage in surveillance of an employee at home or about their everyday business, as long as that surveillance is directly relevant to the engagement of the employee in their work.
And
Alice, sorry.
I was going to say, isn't it true, Professor, that generally speaking, if an employee has signed an acknowledgement document of something, for example, like a policy about whether it be about internet use or about use of the assets of the workplace and various other bits and pieces, and the employee has a suspicion that sort of compliance with the policy is not going on, isn't it true that they can loosely relate that back to a reason that surveillance has been conducted and that there's not a whole lot of regulation of how far you can go before it's too far?
No, well, that's right. An employer certainly can do that, but the problem, as I've been indicating, is that there's no effective legal regulation of this area. So what's happening in the private sector is essentially voluntary. It might be a code of conduct that's been put in place by private investigators or whoever, but there's no effective lawful framework within which the increasing surveillance to which we're all subject can now be maintained.
We've got to go to a sponsors break, viewers, so stay tuned and we'll get back to this hot topic just after the break.